The Seventh Amendment of the United States Constitution promises Americans the right to a jury trial in civil cases. Tens of millions of Americans have lost that right, not through legislation, not through a Supreme Court ruling that made headlines, through clauses buried inside contracts they signed without reading. Your credit card agreement, your phone carrier contract, your gym membership, your bank's terms of service, the software on the device you are watching this on. 81 of the largest 100 American companies now require what is called forced arbitration. When one of these companies cheats you, you cannot sue them in court. You cannot join a class action with other people. The company cheated. You must enter a private proceeding, chosen by the company, that consumers win less than 5% of the time. You did not negotiate any of this. You accepted it by clicking, "I agree." This is the story of how a 1925 law, 3 Supreme Court rulings, and the fine print in every consumer contract in America quietly eliminated the constitutional right to sue. The Seventh Amendment was ratified in 1791 as part of the Bill of Rights. Its text is direct. In suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. $20 in 1791 was the equivalent of several $100s today. The framers of the Constitution understood civil disputes as the primary way ordinary Americans would resolve conflicts with people, businesses, and institutions more powerful than themselves. A jury of neighbors was the check on that power. For more than 100 years, the promise held. When a bank foreclosed on the wrong home, the homeowner sued. When a factory injured a worker, the worker sued. When a company sold defective goods, the customer sued. Juries decided. Sometimes the plaintiff won, sometimes the corporation won. But the right to be heard by a jury of citizens was itself the foundation. Then, in 1925, one federal statute began quietly rewriting the promise. The Federal Arbitration Act was signed into law in 1925. Its stated purpose was narrow. For a century, American courts had refused to enforce private agreements to skip the court system and resolve disputes through a private third party. Business partners who signed contracts agreeing to arbitrate their disputes would find, when the moment came, that they still had to litigate in court. Judges considered such agreements a threat to the judiciary's authority. Business interests lobbied for a law that would force courts to honor these agreements between merchants, between businesses of roughly equal power, who chose arbitration as a faster, cheaper alternative to full litigation. The Federal Arbitration Act was drafted with that purpose in mind. The Senate Judiciary Committee that reviewed the bill in 1925 stated explicitly that the act was not intended to apply to workers or consumers, only to business-to-business commercial contracts. The law passed. For decades, it did what the Senate committee described. Merchants used arbitration. Consumers used courts. Then, starting in the 1980s, the Supreme Court began reinterpreting the Federal Arbitration Act. In a series of decisions, the court found that the act applied not only to merchant contracts, but to any contract with an arbitration clause, including employment contracts, including consumer contracts, including contracts of adhesion, meaning contracts one party writes and the other party either signs or walks away. The 1925 law, drafted for merchants, was quietly repurposed. The court held that federal arbitration law preempted state consumer protection laws that had previously prohibited forced arbitration in certain contexts. The rewriting had begun. 3 Supreme Court decisions over 7 years closed the door. 2011, AT&T Mobility, LLC versus Concepcion. Vincent and Liza Concepcion had been charged sales tax on a phone advertised as free. They tried to sue AT&T. Then they tried to join a class action with other customers, charged the same fee. AT&T's contract contained a clause requiring individual arbitration and prohibiting class actions. The California Supreme Court had previously ruled such clauses unconscionable and unenforceable. The United States Supreme Court reversed. In a 5-4 decision, the court held that the Federal Arbitration Act preempted California law. If a contract required individual arbitration and prohibited class action, that provision was enforceable, regardless of state consumer protection statutes. 2013. American Express Company versus Italian Colors Restaurant. A group of small merchants argued that American Express was using its market power to force them to accept unlawful contract terms. Individual arbitration was economically impossible. The cost of arbitrating each claim would exceed any recovery. The court ruled that the contract's arbitration clause was still enforceable, even where individual arbitration was economically irrational for the plaintiff, even where forced arbitration effectively immunized the corporation from being challenged at all. 2018. Epic Systems Corporation versus Lewis. The question was whether the National Labor Relations Act, which protects workers' rights to engage in concerted activity, prohibited employers from requiring workers to sign class action waivers as a condition of employment. The court ruled that it did not. Employers could require workers to sign class action waivers. Approximately 25 million American workers were immediately affected. Concepcion in 2011, Italian Colors in 2013, Epic Systems in 2018, 3 decisions, all decided along the same general ideological lines. Together they held that forced arbitration clauses were enforceable in consumer contracts, in commercial contracts, and in employment contracts. Together they held that class action waivers embedded in those clauses were enforceable. Together, they closed the courthouse door on tens of millions of Americans. If this is the kind of pattern you want to see exposed every Thursday, hit subscribe. Private arbitration is not run by the government. It is run by private companies. The two largest in the United States are the American Arbitration Association and JAMS. When a consumer or employee is forced into arbitration, the arbitrator is chosen from a panel maintained by these companies. Both parties nominate arbitrators. Both parties can strike names from the list. The remaining arbitrator hears the case. The arbitrator is paid by the hour. Their income depends on being selected by the parties to future arbitrations. Corporations are repeat participants. A large employer or credit card issuer may arbitrate hundreds of cases per year. Individual consumers arbitrate one case once. The arbitrator who rules for the consumer is unlikely to be picked by that corporation again. The arbitrator who rules for the corporation may be picked hundreds of times more. A 2015 Stanford University study examined arbitrator selection patterns. It found that arbitrators who ruled in favor of corporations were selected as arbitrators in future cases 50% more often than arbitrators who ruled in favor of consumers or workers. This is called the repeat player effect. It is a documented, measured phenomenon. The arbitrator's incentive structure is not to be neutral. It is to be selected again. Arbitration proceedings are usually confidential. There are no public records. There is no case law. There is no precedent for future cases. A corporation that engages in a pattern of misconduct against thousands of consumers can be forced to defend each claim individually, in private, with no cumulative public accountability. The system that replaced the courtroom was designed to serve the party writing the contract. The results are documented. The Consumer Financial Protection Bureau conducted a study of arbitration outcomes and found that consumers obtained relief in 9% of the claims they brought against corporations. Corporations who filed counterclaims against consumers obtained relief in 93% of theirs. The American Association for Justice analyzed data from the American Arbitration Association and JAMS. In 2020, consumers won monetary awards in 4.1% of forced arbitration cases. In 2022, that number fell to 0.7%, under 1 in 100 cases. Employees fared no better. In 2022, only 80 employees nationwide won monetary awards in forced arbitration, out of approximately 60 million American workers subject to forced arbitration clauses. The National Consumer Law Center conducted a survey in 2023 to measure how well Americans understood the arbitration clauses they had signed. The finding: less than 1% of consumers correctly understood that the clause eliminated their Seventh Amendment right to a jury trial. 99% of the people who signed the contracts did not know what they had agreed to. In 2017, the Consumer Financial Protection Bureau issued a rule. The rule would have prohibited financial institutions, banks, credit card companies, payday lenders from including class action waivers in their consumer contracts. Consumers would still be forced into arbitration for individual claims. But if a company cheated a large number of customers in the same way, the customers would retain the ability to group their claims together. The rule was the result of a 5-year study by the CFPB. The study found that class actions produced substantially more consumer relief than arbitration in aggregate. It found that arbitration clauses effectively suppressed consumer claims. It found that the elimination of class action rights harmed consumers. The rule was issued in July of 2017. It was scheduled to take effect in 2018. In November of 2017, Congress passed a joint resolution under the Congressional Review Act, repealing the CFPB rule. The resolution was signed into law before the rule could take effect. The Congressional Review Act had never before been used to overturn a completed federal rule on consumer protection. Its use to eliminate the CFPB arbitration rule set a precedent. No rule protecting American consumers from class action waivers has been proposed federally since. One narrow exception was passed in 2022. The Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act allows people bringing claims specifically related to sexual assault or harassment to opt out of arbitration clauses. It applies only to that category of claim. It does not affect any other consumer or employment context. For everything else, credit card fees, phone billing errors, workplace wage theft, defective products, discriminatory employment practices, misleading financial services, unauthorized bank charges, forced arbitration remains the default. The Seventh Amendment still exists. It has not been repealed. It appears in every copy of the Constitution. It is taught in every American civics class. But for tens of millions of Americans, the right it guarantees is functionally unreachable. The mechanism that eliminated it was not a constitutional amendment. It was not a piece of legislation openly debated in public. It was not a Supreme Court ruling that overturned a right by name. It was a 1925 statute, reinterpreted decades later. 3 Supreme Court decisions over 7 years, and a clause buried in the fine print of the contracts that ordinary Americans must sign. To buy phones, rent apartments, use software, borrow money, and go to work. The American right to sue was not taken. It was traded away, one signature at a time, by people who did not know what they were signing. 99% of them. The Seventh Amendment guaranteed that a jury of neighbors would stand between the citizen and the powerful. For most of American history, that guarantee held. It no longer does. The courthouse door is closed. The key is a clause the corporation wrote, and the only way to keep it closed is for most Americans to never notice that it has been shut. The Senate committee that passed the Federal Arbitration Act in 1925 said the law was not meant for consumers. A century later, it is exactly and only what the law is used for.